To learn more about earning college credits with study hall courses, go to gostudyhall.com or click the link in the description. It was 1955 on a Montgomery, Alabama bus. Rosa Parks was on her way home from the department store where she worked as a seamstress. The driver asked her to give up her seat to a white man, and she refused. But it wasn't because she was tired, like a lot of stories say. The truth is that Rosa Parks was a longtime civil rights activist. She fought for the end of Jim Crow laws that discriminated against black people from the 1870s through the 1960s. And her act of civil disobedience on that Montgomery bus ultimately led to the Supreme Court ruling that bus segregation was unconstitutional. The federal courts wield a lot of power over our civil rights. And in a country as diverse as the US, it's critical that we understand what our civil rights are, how we got them, and how we can continue to protect them. Otherwise, we won't know when to stand up or sit down for ourselves. Hi, I'm Chris Vasquez, and this is Study Hall: Power and Politics in US Government. Before we get started, let's establish the difference between civil liberties and civil rights, even though we often use them interchangeably, and the lines between them can seem blurry. Civil liberties are freedoms that are protected so that the government or people in power can't take them away. In the US, they're guaranteed within the Constitution. Think the freedom of speech or the freedom of religion. But civil rights are the actions the government takes to make sure people are treated equally. Civil rights keep people from being discriminated against by the government and private entities, like businesses, based on things like their gender or what racial group they've been put into. Think the right to public education or the right to vote. In this episode, we'll talk about how judges figure out what is and isn't discrimination, and look at some powerful historical examples of both. Not every civil right was written into the US Constitution. Some were granted just after the Civil War via the 14th Amendment's Equal Protection Clause in 1868. It was meant to give all people equal protection by law, meaning people can't be discriminated against unless there's a very compelling reason behind it. So the 14th Amendment intended to expand civil rights, especially to the formerly enslaved. But in reality, it wasn't until the civil rights movement that these rights became more accessible to black people nationwide. And a key way civil rights became more accessible was through the courts. After all, it's up to judges to interpret the laws in cases that involve things like bus segregation, so that civil rights protections can be enforced. Because we're dealing with civil rights and constitutional laws, we'll focus on federal courts, which hear cases that either involve parties in multiple states or situations where federal laws have been broken. At the top, we have the Supreme Court, and below that, there's the 13 courts of appeals, and then the 94 district courts. When federal courts are trying to figure out if a law violates someone's civil rights, they'll consider whether it does so based on certain characteristics of that individual, like their age, whether they're married, their gender, or what racial group they've been put into. For instance, in the US, you have to be 21 to drink alcohol. So technically, the government is discriminating against young people by not allowing them to drink. It can help to imagine the scales of justice here, which might tip in favor of the individual or the government depending on the case. The balance doesn't just shift with the wind though. We have several tests or standards that help. And these tests are a critical part of judicial review, which is pretty much the court's power to strike down legislation that violates the Constitution. Judicial review was established way back in the 1803 Marbury versus Madison case, and it's pretty much the best known and most important power of the court. The first kind of test is the rational basis test, which is when the legitimacy or rationality of a law has to be proven. Basically, the court needs to be convinced that there's a rational reason why the law exists, even if it might discriminate in some way. Like with the minimum drinking age example, it's rational that the states shouldn't allow kids to drink for their own safety and others. The rational basis test is pretty lenient, so laws tend to pass, and because most laws remain intact, the court's scales are tilted in the government's favor here, so they don't have to work as hard to defend their legislation as other tests, like the second kind of judicial review, which is the intermediate scrutiny test. It's mostly used to examine laws that appear to negatively target people based on gender or sex, but have also been used in cases involving First Amendment issues. To pass the intermediate scrutiny test, the government has to prove that the law in question furthers an important government interest. Here, the law not only has to be legitimate, but also important, like in terms of public safety. The intermediate scrutiny test was introduced in a 1976 case, where an Oklahoma policy allowed the sale of 3.2% alcohol beer to women who were 18 or older, while men still had to wait until 21. Oklahoma wanted to promote traffic safety because they said men between the ages of 18 and 20 were more likely to drink and drive. But the Supreme Court ruled that having different drinking ages based on gender was unconstitutional. There wasn't clear enough evidence that it was important to the government's agenda. And they weren't convinced that letting 18 to 20-year-old men buy the 1970s equivalent of a White Claw would compromise traffic safety. Since it's the government's responsibility to make their case in front of the court, they have the burden of proof to show that they're right. This makes the intermediate scrutiny test stricter than the rational basis test. The court's not just asking, is this law reasonable, but rather, is this law in the state's legitimate interest? So fewer laws tend to pass this test, and we see the scales of justice tilting back toward the people who are more protected against potential discrimination. The last type of judicial review is the strict scrutiny test. Most of us are familiar with the idea that there are some protected classes of people in legal terms, and that you can't discriminate against people based on their national origin, religion, or what racial group they've been put into. But strict scrutiny has also been used to examine laws that infringe upon free speech, and the Supreme Court hasn't been consistent about applying strict scrutiny across all of the Constitution. Few laws tend to pass strict scrutiny, because it requires the government to show that using discrimination was absolutely necessary. They have to prove that there's a compelling reason behind their discrimination, so the scales are again tilted in favor of the individual instead of the government. But one of the more infamous Supreme Court cases in US history happened to pass this test, and it had major repercussions for thousands of people. After the Pearl Harbor bombing by Japan in 1941, President Roosevelt passed an executive order that led to the forced internment of around 120,000 people. Almost half were kids, as well as thousands of elderly and disabled people. So in 1942, anyone who was at least 1/16th Japanese received a government notice that ordered them to immediately turn themselves into prison camps. At the camps, people suffered from food shortages, inhumane living conditions, and poor sanitation. Due to the clearly discriminatory nature of the law, some people tried to evade the government and avoid internment altogether. Like 23-year-old California-born Fred Korematsu, who was working as a shipyard welder for the US war efforts until he lost his job due to discrimination. When he received the internment order, he refused to follow it, and successfully evaded the government for almost a month before he was arrested. And while Korematsu was in jail, the local director of the American Civil Liberties Union helped him make a plan to challenge the constitutionality of the executive order. But both lower courts ruled that Korematsu had disobeyed military orders by not reporting to a prison camp. When it reached the Supreme Court in 1944, they also decided 6-3 that the internment order was constitutional because it was necessary to protect national security during the war. Here, the strict scrutiny test was passed. In defense of their law, the US government argued that Japanese people posed a threat to their country. They claimed it was a military necessity. But more than 40 years later, President Carter reopened Korematsu's case, and his conviction was overturned. It turned out that even in 1944, there were intelligence documents showing Japanese Americans posed no real threat to national security. But this evidence was intentionally suppressed and didn't come to light until the 1980s. Then in 1988, President Reagan signed the Civil Liberties Act, which officially apologized to surviving internment victims and gave them each $20,000 in reparations. The US government argued that the internment of Japanese Americans was a matter of national security during World War II. But they didn't make a similar argument about German or Italian Americans, who were also descended from countries that fought in the Axis powers with Japan in World War II. And this serves as a reminder that our judicial system includes judges who are biased, and who might satisfy public opinion at the expense of minority rights. And as we'll see, the interpretation of discriminatory laws has changed a lot over time, reflecting the values and views of those in power, from the district to the state and federal courts, even if judges are meant to be apolitical decision makers. The different judicial tests are important because court cases and the legal precedents they set affect our everyday lives in big ways. How cases are decided and whether discriminatory laws are overturned clearly has big ramifications long after individual cases are settled. Even in the 2020s, we're still feeling the effects of 20th century decisions. As of 2023, there are pending Supreme Court cases that deal with discrimination, focusing now on affirmative action, or the policies intended to help members of marginalized groups with employment and getting into college. There are two cases from 2022. One is Students for Fair Admissions versus Harvard University, and the other is Students for Fair Admissions versus the University of North Carolina. The anti-affirmative action group leading the lawsuits is claiming that it's discriminatory for universities to use affirmative action to create more diverse admissions classes. But Students for Fair Admissions argues that because Harvard receives federal funding and UNC is a public university, they both need to comply with civil rights era legislation that bans racial discrimination in college settings. And they claim that Harvard and UNC are discriminating against white and Asian American students in admissions, violating this act. The question of discrimination in college admissions is a microcosm of a larger debate about equity versus equality in US policy. We're led to believe that the Constitution enshrines our right to equal treatment under the law, but we live in an inherently unequal world, so it's difficult to compare the ideal of equality to the reality of discrimination laws. These cases are still being heard, and our old friend the strict scrutiny test will be used to determine whether affirmative action policies should remain in state-funded colleges. Part of affirmative action's goal is to help members of underrepresented groups become better represented at the undergraduate level, so that colleges better reflect the diversity of our country. But the Supreme Court justices will have final say about whether they think it's constitutional. So if you've ever applied to college or bought a White Claw, you've been affected by the judicial decisions of the last century. It's vital that we build a foundational understanding of this branch of government, its guiding principles, and how it can or should protect us from things like government discrimination. Dissecting the standards of judicial scrutiny helps show us how we ended up with equal treatment according to the law within the US. But it's just as important to remember that laws are always being challenged. So even when something seems set in stone, the 9 people who are nominated to the Supreme Court have the power of interpretation that can change how we live overnight. If you're enjoying Study Hall Power and Politics in US Government and are interested in taking an online course and earning college credit, go to gostudyhall.com or click on the button to learn more. Thanks for watching. See you next time.